be aware that we all are very tired listening to different presentations throughout the day. I will be very brief in my presentation, and if you are interested to continue, then we can have discussion afterwards. I will be basically sharing with you what lawyers, using law as a tool, how they could actually prevent human rights violations, such as torture, extrajudicial killings, disappearances, or sexual violence against women. And I will be giving Nepal, or taking Nepal as a reference. And I will also share some of the experiences that we have working in advocacy forum in Nepal. I would like to separate my presentation in two fractions. One, what roles that lawyers played during armed incidences in Nepal in terms of preventing human rights violations in the country. And in the later section, I will discuss what roles that lawyers are playing after the conflict, aftermath of conflict, to address the legacies of human rights violations that took place during the conflict. 1996 to 2006, we experienced different pieces of legislation, such as anti-terrorist legislations, giving wider rights to the security forces. We also experienced state of emergency, coup, state by the king, a lot of restrictions on our fundamental rights, arrest, illegal detention, torture, extrajudicial executions, forced recruitment, abductions, forced eviction, etc. We still have to address the death, killings of more than 16,000 people that took place during that year. We still don't know the whereabouts of 1,500 lost people, and thousands of people are still suffering from the torture, trauma that they experience, and hundreds of victims of sexual violence are still waiting for justice. So that was the context that we were working 1996 to 2006. And there was a pervasive fear. It was difficult to challenge the atrocities that we were experiencing at that time. There were self-imposed censorship even in the media. We have pervasive culture of impunity. So that was the context where lawyers were playing in terms of preventing human rights violations in the country. At that time, our role was basically to document and monitor what was really happening in society. We were documenting cases of human rights violations. Our own organizations alone has documented more than 8,000 cases of human rights violations, mainly the cases of extrajudicial executions, enforced disappearances, torture, and sexual abuse against women. We had no other legal remedies, but we rolled out legal aid to those victims, family members, whose families were arrested, detained illegally, or disappeared. We didn't have any other piece of legislation to address the problem of disappearances. We used the writ of habeas corpus in terms of challenging illegal detention and disappearances of these people. At that time, it was very difficult for even family members to bring the petition in the court, because there were several incidences where family members were targeted for bringing the writs of habeas corpus in the court, challenging the military, who used to be the authority in detaining civilians into their custody. Even the law, which was existing at that time, wouldn't allow military to arrest and detain civilians into their custody. So as it was illegal that they were detaining civilians into their barracks or into their custodies, they would continuously deny that they were holding any detainees into their detention. So challenging that was a life-threatening job at that time. So family members were very scared in bringing cases when they saw other people being arrested, detained for bringing those writs of habeas corpus. So it was lawyers who initiated bringing writs of habeas corpus in the court. Lawyers were also targeted. for bringing these challenges in the fore. We had amendment in the anti-terrorist legislation that would entail the provisions like anyone that provides direct or indirect support to the terrorists are also the terrorists. Meaning, doctors who were providing treatment to the injured terrorists were also arrested for supporting the terrorists. And some of the lawyers who were advocating on behalf of those who were detained under anti-terrorist legislations were also arrested and detained for being the supporter of the terrorists. So at that time, we as an organization, NGO, started to file writs of habeas corpus. You could also see the mentality, the fear factors within the judiciary. These writs were not entertained in the court. Court started to raise the issue of locus standi, saying that NGOs don't have locus standi in filing cases of writs of habeas corpus, for example. Of course, we challenged this. Later on, court started to entertain the writs filed by the NGO, but initially it was also an issue. We also advocated for rule of law. Nepal Bar Association really took the lead role in terms of advocating for amendments and the notifications of some of the legal provisions that were there at that time, and also against the regime which was there at that time. We also started visiting places of detention. We monitor advocacy forum from where I come, monitors 57 detention centers in 20 different districts. And we started this while we were still under a state of emergency. Our visit to detention centers was very instrumental in terms of preventing illegal detention and torture. Of course, it could not eradicate, but it had some preventative effects. So lawyers, using the constitutional provisions that we had, that detainees have access to their lawyers, in terms of ensuring their rights to have access to lawyers, we would visit detention centers to provide free legal assistance to those who cannot afford lawyers, and at the same time monitor and document what really happens in detention centers and use this information for the change later on. We were in a kind of situation at that particular phase where our space was in a way shrinking. It was very difficult. So that was the moment when we felt we have to reach out to international community. So we tried to use international human rights mechanisms, especially the UN mechanisms that are available. We started to visit Human Rights Commission at that time, Human Rights Council now, seeking for some kind of resolutions on Nepal, so that would establish some kind of international scrutiny and monitoring in the country what was going on in terms of human rights violations. When we started this lobby or advocacy back in 2001, 2002, when already we had skyrocketing cases of enforced disappearances, extrajudicial killings, torture, and so on, there was very little information available at international level. So many countries of the UN did not even know where the country called Nepal exists. So that was the period when we realized that we have to fill the gap in terms of ensuring that information flows exist and international community does care what is happening in Nepal. We started to use different special procedures of the UN, sending a lot of cases to special rapporteurs on torture, for example, or extrajudicial executions, working group on enforced disappearances. We wouldn't get any response from those mechanisms when we were filing a lot of cases or when we were submitting a lot of cases at that particular time. But later on, what we saw was that the special rapporteur on torture coming up with the report before the Human Rights Commission saying that they recorded large number of cases of torture from Nepal. The UN Working Group on Enforced Involuntary Disappearances came up with the report stating that they recorded the highest number of new cases of disappearances from Nepal in 2004. So that helped us to bring Nepal in the spotlight of the UN and also international community at large. So that provided us some space to have some resolutions a resolution that helped us to establish the UN Office of the High Commissioner for Human Rights with the mandate of investigations and monitoring in the country. So back in 2005, we were successful to have the largest mission of UN in the country with the mandate of monitoring documentations of cases of human rights violations, also to provide technical inputs to the government. That particular move helped us to widen the space that we had at that time, and it also helped to increase the confidence of the human rights defenders, lawyers, legal community working in the country at that particular time. It actually contributed significantly to pave a sort of grounds for the bigger political change in the country. As you know, in 2006, we were able to overthrow the system, the monarchy. We were able to have political change. We had significant political change. A lot of people refer that movement, people's movement, as we call, as a revolution. I don't think that was a revolution because actors remain the same. But it was a significant political change that we had in 2006 that also brought Nepal Communist Party of Maoist, which was launching the armed insurgency to the mainstream political forces. That also helped us to declare Nepal as republican, overthrowing the monarchy that we had for many decades in the country. We had comprehensive peace agreement signed that promises to address the legacies of human rights violations. It provides, the establishment of the transitional justice mechanisms, various transitional justice mechanisms in terms of providing justice to the victims, among others. It also provided the political framework, the total transformations of Nepali society, promising that there will be new Nepal with all the promises that parties have made in terms of institutionalizing the change that we were able to achieve at that time. As there was such a big political change and the promise that the legacies of past human rights violations will be addressed and the rule of law will be strengthened, we started to bring the cases in terms of demanding criminal investigations. As there were no investigations on any of those cases of extrajudicial killings in the past, we started to help victims, the family members of the victims, to file FIR, First Information Report, in all those crimes, demanding criminal investigations on those cases. We have so far filed more than 120 cases of FIRs. But the problem the challenges that we faced was that those FIRs were denied. I mean, police would deny even to register the FIR.